I'm Robert Upex, and this is the third lecture in a series of revision lectures on the subject of equity and trusts. The starting point for this lecture is the requirements for a valid trust. I ended the previous lecture by saying a little bit about it, but I want to say a bit more about it now and flesh it out. There are 5 basic requirements for a valid trust, some of which I'll deal with in this lecture, some of which I'll deal with in the succeeding lecture. The 5 requirements are these. The trust must satisfy the requirements of certainty. Secondly, it must satisfy the relevant formalities. Thirdly, it must satisfy the rule of perpetuity. Fourthly, it must satisfy the beneficiary principle. And fifthly, it must be completely constituted. Now, all these requirements are the requirements or certain enough to create an obligation. And the problems arise in cases where what are called precatory words are used. If one says something like, "I would like," or "it is my wish that," or something of that sort, the question is whether those words, which are classified as precatory words, are sufficient to satisfy the requirement for certainty. Well, the answer is if you use words like that, "I would like," or "it is my wish that," then that would not create a valid trust. And by contrast, the words needed to create a valid trust would be the words "upon trust." So any lawyer drafting a trust instrument would use the words "upon trust" because that is those are the magic words, if you like, which will create a trust. Anything less, then it becomes arguable.